Today's session is going to be conducted by Honorable Presiding Officer of DRT 1 Chennai, Dr. N. BADARINATH. For the practitioners at DRT and the tribunals, he doesn't require a big introduction. We have seen him for years in Chennai as the presiding officer, and many of you are well aware of him. And for others from the district bar, I would like to introduce him as one of the formidable presiding officers in DRT over the years which we have seen. Prior to that, he had been practicing various feathers to his hat as an arbitrator, and he had been as a resource person for the subordinate judiciary at Andhra Pradesh, and he had been a very active participant in various sessions during his practice as an advocate in Vizag. And after he has taken over as a presiding officer at DRT, he had been amidst us for the past few years at Chennai. Today, he is going to speak to you about the inquiries and orders in interlocutory applications, which a primary role in the litigation. As a litigating lawyers, we are always concerned with the immediate interim orders which we look at. Rather, even in terms of disposal of matters, we see the interim orders or the preservation of the lists between the parties. So I welcome him, and the stage is now set to him to carry on from this. Welcome, sir.
Thank you, Mr. Om Prakash, for the fine words you have spoken about me. Of course, it's only out of love and affection that you said so. Thank you once again. Very good evening to all the participants. And I'm grateful to the organizers of this webinar for giving me an opportunity to speak on inquiries and interlocutory applications. Let me at the outset submit to you that my today's speech is for the youngsters like me and not for seniors like Mr. Om Prakash, Mr. Satish, Mr. Koka, Mr. Ravindra Prasad, and several others whom I could see from the screen. The reason why I have chosen this topic, which is quite familiar to most of you, is, as said by Mr. Om Prakash, the very importance it has in the adjudicatory process. In fact, it is the lifeline of any list in the adjudicatory process, be it a civil or commercial. And if I can say so, the performance of an advocate is judged by the client by the ability of the lawyer to get an interim order. Thus, it played a vital role in both the fields, from the viewpoint of clients and from the point of the survival of the list itself. Now, what is this interlocutory application, which we fondly call it as IAs? If you refer to the Code of Civil Procedure, probably you will not find any definition to it. However, the civil rules of practice would provide a definition to it. The Rule 3.1 of AP Civil Rules of Practice, which is mutatis mutandis similar to the one that contained, I suppose, in the Tamil Nadu Civil Rules of Practice, says, or rather gives the meaning of interlocutory application as: interlocutory applications means an application to the court in any suit, appeal, or a proceeding already instituted in such court other than a proceeding for execution of a decree or order. So we are today excluding the applications in relating to execution of a decree or order from the purview of interlocutory applications. Now, when are these interlocutory applications are invoked, and why are they invoked? Now, firstly, most of the lawyers here are being the practitioners of civil side, and probably a few of you are on the tribunal side, you all know that there are two important sections that govern the interlocutory applications under the Code of Civil Procedure. One is Section 94 of the Code of Civil Procedure, and the and as per the Section 94 of the Civil Procedure Code, you know that at various stages a provision is made for making an interlocutory application during the pendency as well as after the list is disposed of. They are in the form of injunctions, they are in the form of attachments, they are in the form of stay, they are in the form of appointing a receiver, etc. And broadly, they are called supplemental proceedings, which you could now see on the screen. Now, for the present, rather at the outset, I would like to go to 94C, which speaks about temporary injunctions. And in case of disobedience, commit the person to then. Now, and also go to E. Interlocutory orders as may appear to the court to be just and timely. So the orders are made pursuant to power conferred under Section 94. These are in all over India, as each state can rather amend or modify the order, but not the section. Barring few changes, more or less they are same. Now, let us now deal with the first aspect of that injunction, which is one of the very important interlocutory application, rather interlocutory measure that is always contemplated before the list is adjudicated by the court. And you all know the importance of this use of this interlocutory application. The fundamental principle in adjudication of a civil dispute is that the status quo obtaining as on the date of institution of the list must be preserved. It should not be allowed to frustrate, nor the relief sought for should ultimately become impracticable by the conduct of one of the parties to the litigation. Therefore, in order to preserve the subject matter of the property in status quo, pending detailed adjudication, as you all know, the Indian system of adjudication is adversarial. It involves a lot of time, lot of procedure, and time consuming. Therefore, there is every likelihood of the subject list getting either frustrated or the relief sought for becoming impracticable, if not the status quo prevailing as on the date is preserved. Therefore, that is the objective behind granting of or seeking for an order of injunction by the parties concerned, and it is for the court to consider on the respective merits of the matter that what kind of relief should be given or need not be given at particular stage. But merely because a relief that is sought for in the form of an interlocutory application or through an interlocutory application is denied, it does not mean that the relief has the suit itself, the main relief sought for itself has become infructuous, because anything that is taking place during the pendency of the matter can be taken care of by retrieving what is lost if required. So there are enough provisions in the code, which is separate matter, probably is not in the scope of today's presentation. Now, what is an injunction? Well, injunction is a judicial process whereby a party is required to do or refrain from doing any particular act. It is in the nature of a preventive relief granted as the petitioner fears future possible loss if or injury, because the appropriate word is the injury as used in 39(1) and 2, to prevent a future injury. Therefore, that is what is an injunction. Now, let us now go to section 37 of the Specific Relief Act, which can be put on the screen. Section 37 of the Specific Relief Act prescribes two kinds of injunctions, namely temporary and perpetual. Temporary injunctions are such, as you all know, are to continue until a specified time or until further orders of the court. Please underline the word until further orders of the court, because this would be useful for in due course when I deal with an injunction, whether really it is interlocutory or it can go beyond the suit, beyond the disposal of the suit. That's why I say, please underline until further order of the court, and they may be granted at any stage of the suit. That also please highlight. At any stage of the suit, and are regulated by the Code of Civil Procedure. Therefore, 37 Proviso 1 straight away takes us to Order 39 Rule 1 and 2 CPC, because they are granted under the Code of Civil Procedure, not under the Specific Relief Act. Never a temporary injunction is granted or dealt with under the provisions of Specific Relief Act. It's always be under the Code of Procedure in 39, 1 and 2, then granted by a decree made at the hearing and upon the merits of this suit, and shall bind on the party against whom it is granted permanently. So when we come to the perpetual injunction, well, again, in that situation only we go to the Specific Relief Act. In nutshell, in a suit for permanent injunction, at the threshold when the suit is instituted, an interim relief that is sought for is 139, 1 and 2. And when the suit is tried and comes up for final disposal, then it is the Specific Relief Act provision that govern. Now, let us see this 39, 1 and 2. This is a very, very interesting provision. And this 39, 1 and 2 is, in my considered opinion, is a tool not only in the hands of the suitor, but also in the hands of the defendant. Now we will discuss that. Now let us first see the first part of 39, 1 and 2 of CPC. Now, if we go by 39, 1 of CPC, what it says, it is very, very important. Here also you have to be little more watchful to the section, because it is always said, every time when we read section, we find something new. That is the greatness in our Code of Civil Procedure, which was drafted in 1908. Even today we get new interpretations to these sections. Fine. Let us see what 39, 1 and 2 says. First part of section 39, 1A is quite important for our today's discussion. It says that where in any suit it is proved by affidavit or otherwise. Now, otherwise means affidavit is not always mandatory. If by some other material you are able to convince the tribunal or for the court, most of the time I use the word tribunal. Also, it means that court, because of my acquaintance with the tribunal in the recent past. I use this word more repeatedly. Please also construe it as a court if I use again and again. Now, where in a suit it is proved by affidavit or otherwise, first of all, leaves no doubt that a party can convince the tribunal by a material which need not be an affidavit for the purpose of obtaining an interim order. Next, 1A, that any party in a suit is any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree, or that the defendant threatens or intends to remove. You see, it is only what is required to be projected when we see this provision is that a property in dispute is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree. So, it is to be established, this factor is to be established simply by an affidavit or otherwise. No adjudicatory process at this stage is contemplated by the legislature. That is why it is said it is a temporary injunction. Its life will be for some time that the court fixes, or if it is extended, it will go up to the stage of disposal of the suit. Then let us go to 2, because a detailed discussion we can resort to after I proceed further on 2. 2 is also very, very important. Now, 39.2 is, it has a sub-caption, injunction to restrain repetition of continuation of breach. Repetition or continuance of breach. In any suit, for restraining the defendant from committing a breach of contract or other injury of any kind, whether compensation is claimed in a suit or not, the plaintiff may at any time after the commencement of the suit and either after the judgment apply to the court for a temporary injunction to restrain the defendant from committing the breach of contract or injury complained of or any breach of contract. See, the first part is mainly focuses on property. The second part focuses on contract and its breach. Therefore, the relevant, though generally we say 39.1 and 2, there is a categorization, and we need to identify the nature of list before we invoke. Of course, broadly, the section covers both, and wrong quoting of a provision of law may not be a bar for granting a relief if the relief party is otherwise entitled to by virtue of the merits of the matter. But what I am trying to focus is, there is a lot of distinction in between these two, and the scope of the application of these 1 and 2 is quite different and is wide insofar as 2 is concerned. Please keep in mind what I said now is the scope of 39.2 is wide. I'll tell you how it is little later. I will again get back to this 39.2. Now we have just touched what is 37 of specific relief act. In that first part is the temporary injunction, which we said we just at a glance we refer to 39.1 and 2. Now let's for a while here and cover the other 2 provisions in the specific relief act and get back to the discussion on injunctions. Now next is 38 of the specific relief act, which deals with the perpetual injunction. Perpetual injunctions are granted under section 38 of the specific relief act. Now, as you know, injunction is an equitable relief, and the party who approaches for an equitable relief should come with clean hands. Now, when it is said a party should come to the court with clean hands, today everybody should have clean hands wherever they go, not only to the court. Keep the hands clean, and that is the message that we have, and this corona has given us. Fine. Now, let us see 38. 38, which probably you would see on the screen soon. subject to the other provisions contained in or referred to by this chapter, a perpetual injunction may be granted to the plaintiff to prevent a breach of obligation existing in his favor. See, the very, very interesting language is so interesting here. You need to know the, unlike 39(1) and 2, which was simply worded to give instant relief, 38 has got some different phraseology, because the word used is to prevent the breach of obligation existing in favor, whether expressly or by implication. So breach of obligation is obligation existing in favor of a suitor is the sine qua non. Now again, just compare. When we see 39(1) and 2, simply it is said by affidavit or otherwise, if the court is satisfied that there is a damage to the property or there is a breach of contract, court can grant a temporary injunction. But when it comes to the perpetual injunction, there should be an existence of a legal obligation and then by in favor of the suitor and breach. This cannot be established by way of an affidavit simply or otherwise at the threshold of a list. It requires adjudication. It requires appreciation of evidence. It requires not a prima facie finding, but a finding to the satisfaction of the court. That is how the distinction is brought. So, a prima facie finding, like the balance of convenience and irreparable loss, or the loss that a party is complaining of, cannot be compensated by any other means except by way of granting injunction, are the considerations for a temporary injunction. However, the considerations for 38 are entirely different. The court must be satisfied by whatever material that the party, during the course of the trial, places it, that there is a strong case, a satisfactory case. The prima facie stage will be over and a case of establishing the probabilizing. After all, in civil case, the probabilization theory, not proof beyond reasonable doubt. So the probabilities of proving the case are the consideration. If the evidence put in does not probabilize the case of the plaintiff, then the suit gets dismissed. Only when it probabilizes the case, yes, he is entitled. That is how 38 is concerned. Now, 39. 39 is a mandatory injunction. It's a form of a command to do an act or to undo an act or to restore what has been taken away or to confer what is required, what a party deserves by virtue of the what are the facts of the case or the please take it. Therefore, this mandatory injunction is also the guidelines for granting a perpetual injunction and the guidelines for grant of a mandatory injunction are one and the same. But the guidelines for granting an interim mandatory injunction and the guidelines for granting an ad interim injunction or a temporary injunction are entirely different. Though both are perpetual injunctions, and in case of one perpetual injunction, simpliciter, yes, an ad interim injunction can be granted on certain criteria laid down in 39(1) and 2. But it's not so liberal when it comes to interim mandatory injunction. Though that is also can be considered or in fact considered under 39(1) and 2. The reason is a mandatory injunction is something that restores the status quo ante. Therefore, if a preventive action like defendant attempt to trespass into the plaintiff's land can be simply addressed under 39(1) and 2. A mandatory injunction that the wall demolished by defendant be immediately a direction to restore the wall cannot be given. Because there, unlike a prima facie case, here a strong prima facie case has to be established. And the final chance of success in the suit, the criterion is little more stringent, though the procedure is same. So it depends upon the facts and circumstances of the case that in a given case, whether a temporary interim mandatory injunction can be given or not. Now here I pause and take back to the proceedings under the Surface Act for a while, because I could see some of the lawyers practicing in tribunals in this meeting today. Let us say that before an applicant comes to the court, the applicant is dispossessed physically and he files an application under 70. Then he asks the tribunal to restore the possession by weapon interlocutory application. Then the question would be whether we can restore the possession at that stage, or do we have to wait till the SCA is disposed of. Now there is a full bench judgment of the Chennai High Court in this regard, headed by Honorable Justice Rama Subramanian, as he then was, in Vijay Lakshmi Mills case, wherein it was held that a restoration of possession at that stage cannot be granted because it is in the nature of a mandatory injunction. So the principle is a mandatory injunction cannot be granted at the threshold ordinarily. Ordinarily, I'm not saying that there is a blanket bar or embargo. Nevertheless, we see with a different outlook when interim or mandatory injunction is prayed for, unlike in an interim injunction. This is the one important feature of 39 of the Specific Relief Act. Now, let us see one area where we always, people going by the definition of the interlocutory order. Interlocutory means it is not final, it is temporary. Whether the injunction court can grant an injunction even after disposal of the suit. Many a times, the courts return the applications when filed after the judgment is delivered for an injunction by the unsuccessful plaintiff or by the defendant for an injunction, even after the disposal of the suit. Now, do you agree that the court retains the power after disposal of the suit to grant an interlocutory order in the form of an injunction? Well, would anyone say that the court has power, or would anyone say that it cannot be granted? Mr. Satish, you want to answer?
Sir, to my little knowledge, sir, to enable the party who was unsuccessful in getting an interim order to approach the higher court, till such period, he may seek protection before the same court. That is my humble opinion.
But why don't we go to a particular section and say, do we have a section at all?
Yes.
Don't we have?
I'm sorry, sir. I could just now, I cannot recollect it because in fact I had the opportunity of getting such order.
Deliberating. We are deliberating. Enjoy this. That's all. That's all.
In EP, normally it is done, sir. In exhibition.
It is done. Okay, fine. Now,
Please.
please.
So Ravindra Prasad wanted to say something.
Yes. Hello. Yeah. Not audible. Hello.
He's saying about order 41, but it is not so audible.
No. Please, can we have order 39 rule 2 on the screen, please? Order 39 rule 2 and 37 of specific relief act, both. Okay. 39.2. Yes, wonderful. See, this is that's what I said. This is a very funny provision, and the CPC reading will make us so enlightened. Right, fine. I will now read 39.2. In any suit for restraining the defendant from committing a breach of contract or other injury of any kind, whether compensation is claimed in a suit or not, the plaintiff may, at any time after the commencement of the suit, and please note this, and either before or after the judgment, apply to the court for a temporary injunction. So we have a clear provision in 39.2, wherein we can tell the learned judge, if at all your application is taken on maintainability, say this is the provision. Now, not only this, let us see 37 of specific relief act. So, because I said I would get back to this when I said the reason is this. Section 37, first part, temporary injunctions are such as are to continue until a specified time or until further order of the court, and they may be granted at any stage of the suit, and are regulated by the Code of Civil Procedure. So no need for going 151 to go resort to 151. We have enough clarity from section 37 and 39 rule 2. Now, interestingly, we also have a judgment from the High Court of Madras in this regard. In fact, this judgment reported in AAR 1986 Madras. I can give the 1989 Madras, page 105. In the matter between Layman's Evangelical Fellowship versus K. Kishorila. Now, this is how the Madras High Court has said. It is to be pointed out that the words court or other injury of any kind can cover and enable the plaintiff respondent to invoke 39(2) CPC even after judgment. So, very clearly said that even after judgment. So, then now the point is, then what is the definition of interlocutory? It can't be like, it is extended. It is extended beyond the suit. Then again I think we can have an answer to it. It is extended till what? It can at best be extended till the appeal is decided. Then what is an appeal? Appeal is continuation of the suit. And I remember if it is 113 of CPC or 118 of CPC, it says all interlocutory provisions that are applicable on the original side are also applicable to the on the appellate side, and when an appeal is taken. Therefore, now the definition of interlocutory is now became so wide because of this provision. Not only this, please see order 40, receiver. The very provision itself says that receiver can be continued even after judgment. In fact, mutandis, the very same provision has been put in 1918 of our RDDB Act. And we have cases where receivers are allowed to continue even after disposal of the OE. Then how is it interlocutory? So these are the things. So literal meaning or the definition that is given sometimes by interpretation of law or by virtue of the provisions stands expanded. So this is what I felt that the the scope of 39(1) and 2 is so wide insofar as grieving relates even after disposal of the matters. Now let us come back to the injunctions under RDB Act, Recovery of Debt and Bankruptcy Act 1990. Well, you all know that till recently we had section 19 sub rule 4 sub provision 12, and that provision has been deleted. We don't have. What was that? It was power to grant interim injunctions. Today we don't find that provision. That has been deleted in 2016. Then is that we cannot grant injunctions. And what are the ways in which the parties can get injunctions when they move a claim or a counterclaim before a tribunal, which is entertainable by the tribunal? Now, let us see. Normally, injunctions have to be asked for in a civil litigation. But it's peculiar that under the RDTB Act, you get an injunction without really asking for it. Very funny and interesting, of course. Let us see how it is. Let us see section 19 of the RDB Act. I'm sorry I didn't inform about this before to the organizers to have it ready on the screen. Anyway, I will. It is a very brief provision. You all know that section 19 is the lifeline for the entire RDT, where everything is governed mostly under section 19. Filing, adjudication, and then finally delivering a final order under 19. Now, let us see first 19(3). Yes, let us see 19(4), which is a newly in a 2016 amendment, not very new. Now, it is very, very interesting to see here that the tribunal shall have to grant a kind of an injunction even without there being a specific prayer sought for by the applicant. This is how it is. When an application is filed, you know that the bank or a financial institution would state that what are the properties secured by the borrowers and their approximate value, and then what is the outstanding debt, and whether the existing assets, securities are sufficient enough to safeguard the final interest or the outcome of the litigation in favor of the bank. This is what broadly section 3A says. Now let us go to subsection 4 of section 19. It says on receipt of an application under subsection 1 or subsection 2 of 19. Wonderful. 19, because 19 is like order 7 rule 11, order 7 rule 1. Here we have 19(1) and 19(2). Then on receipt, what is the duty of the tribunal? It is not the responsibility of appears, not the responsibility of the applicant, but it is a duty of the court. Let us see the language here. On receipt of application under subsection 1 or subsection 2, the tribunal shall issue summons with the following directions. So the summon itself should contain a direction, and it is by tribunal. Normally, you know, summons are issued by the registrar or the chief ministerial officers of the particular court. But here, summons by tribunal. You know, under the RDB Act, tribunal means the single person, that is the presiding officer. Rest are all the staff of the tribunal. Tribunal does not include the recovery officers or the registrars. It is only the presiding officer. Therefore, it goes under the seal and signature of the presiding officer. Peculiarly, summon goes. right? Like warrant and summon in the criminal case, warrant is signed by the magistrate, summon is signed by the CMA. Likewise, here also, summons are served, signed by the registrars, not by presiding officers. But now the mandate is, under this section is, that shall issue summons, the tribunal shall issue summons with the following directions to the defendant. A, to show cause within 30 days of service of summons as to why relief rate should not be. That's the main relief. Now come to it. B, direct the defendant to disclose particulars of the properties or assets other than the properties and assets specified in A, B, and A. So, straight away the tribunal shall issue a direction to the defendants to disclose your assets, if any, other than those you know well, or declared by the defendant. What is declared is normally the mortgage property, when it comes to immovable properties. Then that is not required, but other than those disclosed, the tribunal will have to issue an injunction or a direction. It is in a way interim mandatory injunction, because at this stage there is no opportunity contemplated to the defendant. What is required to be done by the defendant is, he is given time, 30 days time to disclose. After that, the matter has to be closed. And if there is a non-disclosure willful, then there is a procedure to give notice and try him. And if found to have concealed certain assets, then action for contempt of imprisonment can be given. So what is this injunction then? Is it not so harsh? Of course, it is a special legislation. Public money has to be, you have to get back the public money. Therefore, in that context, I'm not here to debate on that. It is a law, and I'm bound, and everybody is bound by that. No, sorry. Now let us see this. There's one more injunction. One more injunction. That is to restrain the defendant, to restrain the defendant from dealing with or disposing of any assets and properties disclosed under C3A pending hearing, the disposal of application, or any application filed for attachment. See, it is like, firstly, there is an obligation on the part of the applicant to disclose what are the assets given as a security. And then there is a duty cast upon the court, tribunal, to issue a direction to the defendant to disclose your other assets as well within 30 days. And then restrain him from alienating the other assets till such time, till the hearing and disposal of the application. File for attachment means the power here of the tribunal is so wide that we give a direction to the defendant to disclose your other assets, and once it is disclosed, the applicant gets opportunity to seek an attachment before judgment, because this is not a mortgage property. So unless an attachment is taken, it will not serve the purpose. So enable the applicant to file a petition for attachment before judgment of those properties, and till such time restraining that person from alienating it. This is an injunction. Whether specific relief act takes care of it, or whether 39(1) and 2 takes care of it, or anything, it is an injunction given in the statute without being specifically prayed for, without being asked for. Straight away, the court has to give. Now, there is one more injunction. One more injunction apart from this. Let us see 4A. Let us see 4A. There is another provision inserted. Notwithstanding anything contained in section 65A, that is transfer of lease and all that, that also been bypassed and said the defendant on service of summons shall not transfer by way of sale, lease or otherwise, except in the ordinary course of his business, of any of the assets over which security interest is created to that extent is okay. And other properties and assets specified or disclosed under subsection 3A. So this injunction is extended not only to the properties which were given as security, but also to the properties which are not covered. So they are exposed to two interlocutory orders without there being any proper inquiry at that stage, without there being a proper application from the suitor. One is attachment, is a provision for seeking attachment is made. Till that is decided, an injunction not to alienate. Now, this alienation can be done only with the leave of the court, and leave can be granted only after giving notice to the creditor. So this is an injunction that the RDB Act has given. Therefore, you can see the changes that the law is taking place. Relief of equity. If injunction is an equitable relief, then does it also mean that, or does it not mean that, that without even examining the things, without even a proper request, granting it is proper under? That is a different arena, but we are implementing it. I'm only trying to show for a limited purpose of when we are talking about injunctions under the Specific Relief Act or under the temporary injunctions in 39(1). And when we see this, see the huge difference. There is no possibility of dismissing a petition for of this nature by the tribunal. We'll have to give it. Next, now this order, this injunctions orders. Now one more problem that a defendant faces is, if in replying to the summon of the tribunal to disclose the assets within 30 days, if there is inadvertent omission, a bona fide omission may be different. But if it is found that he had concealed, he can be sent to jail for 3 months. Of course, after giving notice. What is required to be shown by the plaintiff? Yes, this property was available, but he has not disclosed it. That's all. It's a commercial transaction. Malice and all those things are not. We don't go deeper into it. So this is a kind of an injunction that 39 which is totally different to one that is contemplated under the Specific Relief Act provided under the RDB Act. So now this injunction is a temporary in the mandatory form. It is an injunction without notice. It is an injunction without a specified time of it being in force, but specifying the defendant to comply within that time. Lest you will be facing problem. This is what you find a huge difference between an injunction under this act and injunction under that. So therefore, a suitor need not worry. An applicant in a proceeding before tribunal is not at all worried because of striking down or removing earlier 1912, which dealt with injunctions. It is now made more in favor of the applicant rather than the defendants by the legislature. Of course, in the public interest, that's different. Therefore, this is an area where, insofar as tribunal is concerned, to deal with issues. Now, in the tribunal also, we have a petition for attachment, which is an interlocutory order. And similarly, we have in the civil and the commercial litigation before other fora under 38 Rule 5. There absolutely no difference. In fact, 38 Rule 5, mutatis mutandis is copied and followed in RDB Act. So another kind of interlocutory order that we find in RDB Act mostly used is the attachment before judgment. I will also deal with that in my separate chapter for I've made a brief note on that. I'll deal with it. Then we have commissioners like what we have in under Order 26, but with a limited scope. again is a problem here. You can't expand, because I would just in nutshell deal with RDB and then get back to the main subject again, because this is also a part of employment. Now, you see, under 1918, there is a provision to appoint an advocate commissioner, but under 1918 subrule E, it says, appoint a commissioner for preparation of an inventory of the properties of the defendant or for the sale thereof. Inventory of the properties or for sale thereof. Now, beyond that, there is nothing specified. But if you see Order 26, it has another almost 14 sub-provisions or so in 26 itself, for various situations to meet. So here also scope is limited. Of course, the principles are same. Now, before I go to the discussion on commissioners and the CPC, here I may pause and say one thing. The experience here in the tribunal makes me to say this. See, an appointment of an advocate commissioner, be that under the DRT Act or under the civil procedure, can be done without notice to the defendant. Because it's settled now, I have got 13 of judgments on my screen and I can pass on. There's no doubt, everyone knows that. A commissioner can be appointed ex parte. But can the commissioner execute the warrant without notice? Now the problem is, whenever an ex parte commissioner, when a commissioner is commissioner appointed ex parte executes the warrant, the certain section of the advocates are in the feeling that it can be executed without notice, because of the reason that they say if notice is served, that person will take away the vehicle from that area, the property from that area, or even prevent the advocate from coming in. See, these are the difficulties of the lawyers, but the mandatory requirement cannot be served. We cannot circumvent it. So, it is necessary that an advocate should serve notice. That need not be in advance. That can be at the time when he executes. The section is very clear. At the time of execution, no prior notice. Prior notice means what? When he goes for execution, he need not, he can say, if you want 10 days after, I'll come and take your vehicle. That's a different matter. But he can go to the spot, give notice, and take it. So what is required is a notice. The length of the time of notice may not be of much relevance, because given the language, the section. Therefore, please note that an appointment of an advocate commissioner ex parte is different from execution of a warrant by the advocate commissioner, which shall invariably be with notice to the opposite party. Now, let us come back to the injunction. Now, let us see what is the injunction and trespassing. Can an injunction be against a trespasser? Well, you all know that the possession of a trespasser is recognized, because the fundamental principle is a person in possession of the property shall be, who is put in probably lawful possession, should be dispossessed by due procedure of law. But whether a trespasser's possession is a lawful possession or not, that is for the purpose of again, please underline this, for the purpose of granting an injunction, it doesn't matter. It doesn't matter, because way back in 1968 itself, Honorable Supreme Court has held that a trespasser is entitled for an injunction. This is in the 69 Supreme Court is followed in AR 1989 Supreme Court, page 2097, wherein it is said, I just read a small passage. It is well settled law in this country that where a person is in settled possession of property, even on the assumption that he had no right to remain in the property, he cannot be dispossessed by the owner of the property except by recourse to law. If any authority were needed for that purpose, we could refer to a decision of the division bench of the Supreme Court in Lalu Yashwant Singh versus Jagdish Singh and others, 1968, to Supreme Court, 1968 to SCR, page 203. Therefore, in India, persons are not permitted to take very forcible position. They must obtain such position as they are entitled to only through court. Therefore, now there is no need to debate on much whether on an aspect whether or not a trespasser is entitled for an injunction. Then a co-partner, can he seek an injunction against the other co-partner? It is also well settled that the co-partner cannot seek an injunction restraining the karta or the other co-partners from alienating the joint property, because the co-partner presupposes it. He can maintain injunction against third parties, he can maintain against the other fields, but not against the co-partner or the karta of the joint family. Now, so far we have covered the areas where a suitor, principal suitor in a suit, seeking for an order of injunction. Now let us look at the opposite side also, namely the defendant. Can the defendant also seek an injunction or not? Is also in a suit, is also a well settled proposition, and most of you must be aware of that. But nevertheless, as a part of my presentation, I felt that I should also cover this. It may be just for those who are unaware can take note, and those who are aware may even ignore. Now, see whether a defendant. Now, we need not go to a decision on for this aspect, though I have decisions to cite readily. The very section 39(1)(a) provides for any party to the suit to pay for an injunction. Like I said, 39(2) says that a 39(1), please. When in 39(2), a court can give injunction beyond 39(1)(a). It said there is a clarity given that the defendant also can pray for an injunction. Now we have a authoritative pronouncement of this by Sri Justice M. Jagannath Rao, former judge of the API Court and the judge of Supreme Court of India later, in a very famous case where we always used to quote this, Javadi Sambamurthy versus C.H. Srinivas Rao, 1987, to Andhra Pradesh Law Journal, page 97. Now I read out what it is. I also have the Madras and Kerala. I will also place, because this is the earliest, so I refer to that. Now please see how nicely it is said. The object behind subclause A of Rule 1 of Order 39 appears to me to be to preserve the property intact and not allowed to be damaged or wasted or alienated or sold by any party, be the plaintiff or the defendant pending the suit. For that purpose, an injunction could even be granted in favor of the defendant and against the plaintiff. In fact, if such a relief is granted under clause A, it would equally subserve the ultimate relief that may be granted in the suit in favor of plaintiff, or even in case the suit is dismissed, so that defendant is left where he is so far as the property is concerned. It's not that the suitor should always win. There will be cases, there are cases, and there have to be cases where this plaintiff has to be non-suited. So in that case, what is the situation for the defendant? Status quo as on the date. Why not defendant also seek for it? So this is the spirit, well explained in this judgment. Then we have 89 Kerala, AR 1989 Kerala, page 81. And then we have 1996 to Madras Law Weekly, page 216, wherein it is said, it is not that a plaintiff alone who can apply for an injunction under this rule. A defendant can also apply for an injunction against the plaintiff in respect of any act covered by clause A of this rule. But the defendant can move a temporary injunction against the plaintiff without filing any counterclaim only when the relief claim arises out of plaintiff cause of action or incidental to it. So there is a rider here. That's why, but see, section 39(1)(a), there is no such embargo. However, by virtue of judicial interpretation, it is also said there should be a counterclaim. This is how the law is expanded. So one has to take care of 1996 to Madras Law Weekly, page 216. When situation demands an injunction from the side of the defendant, that is now the scope of inquiry, because inquiry is a part of my today's submission. Inquiry, it has got two facets. From the viewpoint of lawyers, from the point of the judge who is listening the submissions on interlocutory applications. I think I can skip the latter. Coming to the submissions of the lawyers or for the suitor or for the opposite party. In interlocutory applications, as you know, the settled guideline is that roving inquiry and final adjudication or a formal adjudication on the merits of the case is not called for or uncalled for or not contemplated. Because what has to be decided on adjudication cannot be done at the interlocutory stage. So that settles the entire issue. But we do find situations where interlocutory applications are argued for a longer time than the main case itself. And that's why I said it is always said the lifeline of a list is for survival of a list is the interlocutory application. And advocates also enjoy doing a lot of work on interlocutory orders. Of course, that doesn't mean that not in the final stage they will not. They certainly doing it. But this is the difference. So in interlocutory applications, and again one thing we also should know that see the finding is given on the interlocutory application after its disposal. We need not be confined or struck to when the very same application for permanent injunction is considered. The court can vary from what it come to conclusion while deciding an interlocutory. So that is one aspect lawyers also can keep in mind, that this may ultimately, this is not a finality. As I said at the beginning, interlocutory is something temporary, something for the time being, something to preserve the status quo ante, something to avoid the damage. So this is only a lifespan of till such time, but not like a 138 or 139 or 100 the 19(4) of the RDB. Therefore, the scope of the inquiry, as far as we are concerned, I think now we can, because I'm also conscious that I'm facing very experienced lawyers, so therefore I can safely skip that. Now, right, next one thing. Inherent powers, can they be invoked for grant of injunction? This is another area where there are divergent views. Because under the 151 of CPC, I'm talking about inherent power means court only, not tribunal. Tribunal doesn't have any inherent power. Though every day lawyers say before the tribunal that under 1924, omnibus powers are there, tribunal can do anything and everything. And also say, referring to transcourt, that the court can go beyond CPC. And sometimes they elevate us beyond our position and take us to very higher positions during their submissions when it comes to the powers, when the arguments are on the powers of the tribunal. Be that as it may. Insofar as a tribunal is concerned, no inherent power, because a tribunal is a creature of a statute, and whatever the statute conferred, one has to stick to it, and there cannot be any inherent power. And so that's my view insofar as inherent powers of the tribunal are concerned. But a court has an inherent power. In fact, according to me, one of the fundamental differences between a court and a tribunal is lack of inherent powers insofar as tribunal is concerned. And secondly, a court is always presided by a judge, and under the CPC also, a court is defined which is presided over by a judge. But tribunal is not. The presiding officer of the tribunal is not a judge, though he performs the functions of the judge, and he is a court for a limited purpose, as mentioned in section 20. That in that view is also a judge for a limited powers. Leave that right now. Now, inherent powers. Now, my question is, when there is a specific problem, we are talking about injunction or interlocutory order. Let us say any interlocutory order, like appointment of a receiver, commissioner, or injunction, attachment. All these are all. Admittedly, these are all covered by certain certain specific provisions. Now, when we have a specific provision for grant of these interim reliefs, is it proper to go to 151 and say it's an omnibus provision and why don't you give it? You have the power, yes, but do we have to grant under 151? What is the view of the listeners? Can we 39(1) and 2, 26, 38(5), yet 151? Because my understanding is that when there is a specific provision available, inherent provision are like 151 cannot be quoted. If that is the right, then the answer is out. But take a situation. We have catena of judgments, and if I can quote the earliest is Varadacharinu versus Narasimhacharinu, AR 1926 Madras. Maybe the genesis of the law in this. Wherein it is said, I read out. There is a difference of opinion between the high courts on this point. One view is that court cannot issue an order of temporary injunction if circumstances do not fall under the provision of 39 code. However, in the recent ruling of the that was the view of the Madras High Court. In the recent ruling, what it said that the court, we are of the opinion, after considering all that, Supreme Court said, not very recent of course, it is 1952 Supreme Court, we are of the opinion that latter view is not correct, and the courts have inherent jurisdiction to issue temporary injunction in the circumstances which are not covered by the provisions under 39 Code of Civil Procedure. Now, what does it mean? Does it mean that court can grant injunction in every case, or 151 should be used sparingly? Any answer? All right, I'll get that. Now, see, insofar as 151 is concerned, if a case is covered under 39(1) and 2, no question of invoking 151. That is what the Supreme Court had said. However, there may be instances, situations which are not covered by 39(1) and 2. Therefore, you can't leave the party without a remedy. For them, 151 applies. So we have to make a distinction between the relief sought for if not covered by these specific provisions. There are several situations warranting intervention which are not specifically covered under these interlocutory main orders. Then 151 is the remedy. In other words, the essence of that is, if a case, then in that case, we will also have one more question. Supposing a case is under 39(1) and 2, ingredients are not satisfied, like the Prima Facie case, balance of irreparable loss. Yet under 151, the court can grant injunction. That is another question went to the High Court, and it was answered in 1995 to ALT, wherein it is said the difference between use of 151 and 39(1) and 2 is that when a case is not covered by 39(1) and 2, yes, 151 can be invoked. But if a case is not even felt fit to grant a relief under 39(1) and 2, You cannot invoke 151 and give him a relief. So a case which is not fit under sorry, the time, Mr. Om Prakash, Mr. Satish.
Please carry on, sir.
Can I carry on?
Yes, please
For 2
carry on,
minutes,
sir.
sorry, the time,
Please,
I could not stick to it. Fine. So in nutshell, what we have to do is that, yes, we cannot go for an injunction under 151 when it is a case failed, under 39, 1 and 2. Now I would skip the other things and go to stay orders. Stay order also is an interlocutory order. Now normally choose an account. Okay, I can. I have to get into it again. You could see me. You could hear me.
Yes, sir. We could see you, sir.
Fine. I'll
hear you,
even if you can hear. Now the stay orders. See, the stay order is a very important field. Stay. Now it is more important for us. Stay home, stay safe. So stay is so relevant, not only from the viewpoint of Code of Civil Procedure or under the RDB Act, but from the viewpoint of our health today, that stay home and stay safe. Now what is this stay? Now the stay orders, normally we talk about under 41 or under 151 or under section 10 CPC alone. Normally we don't refer to several of the other provisions where a stay can be invoked. Generally stay is sought for when the suit is disposed of by the trial court, the unsuccessful party, when in an appeal files before an appellate court, files an application under 41 and then files a stay petition under 5 and then tries to get a stay order. That is one way which is very popular among the lawyers who go in appeal. There is the other way where by the same court, stay by the same court, that we have under 2126, the court which passed it. These are the two things, the stay. But there are several instances whereby a court can, in some of the instances, can even suo motu stay the proceedings, which I wanted to bring into your notice. One such is under Rule 6, Sub-Rule 14, capital A, Sub-Provision 5. Very interesting provision. Now, this is in respect of the disclosure of the particulars of the registered office of the defendant. You know, when a defendant is a company and its registered office is then it should have an office registered, and its address is the address for the purpose of service upon notice, summons, etc. Though in most of the cases, parties are giving corporate addresses when even though the company is a registered company, it's mandatory that a registered office should be given. Now let us see what this. Can we see it on the screen? Order. This order 6, Rule 14A, Sub-Provision 5. Now, this rule contemplates order 6. Okay. Now, this rule contemplates given address and the details of the
Sir, order 6, Rule 14 is here, sir.
Yes. Now, 14. Yes. Sub-Rule 5. Yes. Go to a bit now. Last Sub-Rule 5. Where registered address? 14A, Sub-Rule 5. Just little go up. Yeah. Where the registered office of a party is discovered by the court to be incomplete, fictitious, the court may, either on its own motion or on the application of any party, order, in case of where such registered office was furnished, the address is not furnished, in case where such registered office is furnished by the plaintiff, stay the suit. See, here is a suo motu. The court can stay the suit itself. There is other situation where under order 10, sorry, section 10, na? Yes, section 10, suit is stayed, where the parties are saying the list is covered in the present list, the dispute in the present list is also covered squarely by the previous list. There also, but that is on an application by the party. But this is a very important provision, 14.5a of order 6. It says that the court on its own motion can stay the suit because the suitor had has not given complete address of the registered office, or the address found to be incomplete or fictitious. That is, so this is one area where we get the stay, order of stay that can be taken. That is where the courts can grant suo motu. Also on an application, that is different. Then, as I said, 2126 is one where. Then 2159 of the stay. Of course, when you go by the definition of interlocutory, this 21 field is of the definition of interlocutory, but nevertheless, it is an order. It is an order interim in nature. That is why I always say that the definition of interlocutory application requires now a relook. It has to be revisited and widened. We can't, of course, on the execution side say we are execution application and all that, but nevertheless, you are granting a stay on the execution side. You are granting some relief of interlocutory and till the main appeal is filed or some claim application is decided. Now, why I am referring to 2159 is, which is a claim application by a third party, their stay is granted. And there, the original proceedings apply because it is decided like a suit. That's why I say this 2159 is one important area where the stay is, which is again an interlocutory order, because that will survive only till that claim application, which is to be decided like a suit, is decided. Then we have Order 9 Rule 13. Order 9 Rule 13 also. In that also there is a provision to stay. There also it is again the provisions of interlocutory application. This is again after the suit. It is not 9.7 but it is 9.30. Now today against the order setting ex parte, if the order is passed ex parte, then two remedies available are either file a petition before the same court under 9.13 or go to the appellate court and get it. Now today, I think it was in the February, the Supreme Court delivered a judgment. Try to place it. Now there is an entire controversy on what is ex parte has been resolved. What is an ex parte judgment? Now it is not earlier. It is said that participation and all that. The only thing is what is said where parties are not the cross-examination of witness when not done. When cross-examination of witness is not done, not given up. There it's a case of exception. So that is another area where we can later discuss, an interesting area. Then we have injunction, stay under 41, which I all said, and most of you are quite conversant with. And we also have an interpreter suit under 33.5, where also there is a stay. And then 37.4 also provides for grant of a stay. Now, finally, one aspect. You all know that when an injunction Hello, could you hear me? Hello.
Yes, sir. We are hearing you.
There's one point with which I will come to. See, we have a provision in the Code of Civil Procedure. Of course, it has a limited procedure, a limited application. That is 39, Order 39, Rule 7. whereby the court is not bound to record reasons for grant of injunction. In the inquiry part, I skipped the part of the court or the rule of the court. I should have mentioned this. See, the court has a duty to record reasons whenever an injunction is granted ex parte, because the rule is to order notice before grant of injunction, and the exception is dispensing with. When in notice is dispensed with by reason of delay, the very object of granting injunction should be defeated. Then only it can be dispensed. But that exercise is not required under 39 Rule 7. You can see it very clearly. Therefore, that is, of course, as for the role of the court. And lawyers can have that in mind and then accordingly then make a presentation. So, friends, I know I've exceeded time and probably the brief also. And then let me honestly tell you that I availed this opportunity only to refresh my memory and get back into my good olden days of practice, and then also keep afresh myself of the law that I little whatever I learned during my practice time, and share the little that I have with you. I thoroughly enjoyed, and any questions you have, you're welcome. And thoroughly enjoyed. Hope I've delivered something useful to you.
Thank you, sir.
Sir, there is one question by one Mr. Chellimuthu. He has asked, is there any specific provision available in the code where section 151 cannot be invoked?
No. See, once in 151 itself, he says inherent power. Inherent power is a power which is not specifically specified, right? You have within you. When you have a division between what is specifically available, then what other than what is specifically available is the inherent power. So by inference, it is clear that inherent power is not that power which is not expressly there. And by getting of rulings, it's by interpretation, judicial interpretation, that when there is a specific provision available, resorting to inherent power or a provision is not proper. Only those cases, even the Supreme Court judgments which I cited, categorically have said that cases not covered under the specific provisions can be dealt with under 150. Hope I am clear.
Sir, Mr. CSK Satish has got a couple of questions. He will be asking you, sir.
Yes, Mr.
Sir, at the outset, sir, thank you very much for your thought-provoking and enlightening lecture, sir. Sir, can you able to hear me, sir?
Yes, we are hearing you. Yes, proceed.
Sir, my question
Yes.
is regarding the difference between Order 39 and Order 39 Rule 1 and Order 39 Rule 2, sir. Sir, you are kind enough to bring to our attention, which was quite unknown to us, or we have not keenly seen, that in Order 39 Rule 2, there is one word at any time after the commencement of the suit, either before or after the judgment.
Yes.
But that word is, I find missing in Order 39 Rule 1.
Right.
And that being the
right.
case, sir, because Order 39 Rule 1 talks about the property being damaged or danger or alienated. But Order 39(2) talks about breach of contract.
Yes.
And that being the case, can we put to use the word after judgment, or are we entitled to file an application
Yes.
after judgment passed by an honorable court under Order 39 Rule 1?
Yes. In fact, that was the question very well addressed in the judgment of the Madras High Court, which I have referred to. See, again, there are two parts of entire 39 192 relied on in the judgment.
Yes.
One part is what I said, before or after the judgment.
Yes.
But the other part is, please see, the judgment again I'm reading the important, the relevant paragraph. It is to be pointed out that the words or other injury of any kind, other injury of any kind can clearly cover and enable the plaintiff respondent to invoke Order 39 Rule 2 even after the judgment. See,
Fine.
not just relied on the word after judgment, before or after, and not that, because part 2 deals with the contract, breach of contract. Part 1 deals basically with the property. Basically, it does not exclude anything, but basically it is. But when the judgment is delivered, it covered both 1 and 2, because you find injury of any kind.
Yes, sir.
Injury is there both under 39(1)(a) and 39(2). In fact, the essence of the interim injunction is that there should, in the case of an injury only, it should be a legal injury, what we call. Therefore, in my view, it is a broader interpretation, and then Madras High Court rightly said so. That's why it relied upon the phrase or other injury of or apart from that or other injury of any kind. So
Fine.
we have to that way. And secondly, I said under 37(1) also, it shall be in force till such time.
Yes, sir.
So what is a suit? Suit will not end after its disposal. Suit will continue till the appeal. Appeal is a continuation. Why not it be read in that way? Appeal is a continuation of a suit. And then 113 or 118 PC of CPC section says that this interlocutory would continue and apply even in the appellate stage. Therefore, this is like if a stay is granted under 21(26), then again it is continued under 41. There is a continuation of proceedings. That way also, yes. That's what my limited. That's what.
Fine. Sir, my next query is regarding the prima facie case. Normally, we lawyers, while drafting pleadings as well as addressing the honorable judges, we try to impress them saying, I have a very strong prima facie case. Now, what actually the magic word prima facie case means? Does it mean an arguable case or a strong case on merit or a person who has all likelihood of succeeding the case? How we can understand that, sir? Prima facie.
See, all the three ingredients which I have just stated,
Yes, sir.
constitute a prima facie case. See, prima facie case is that at a first look, for example, take how if I am the judge in your matter, what would I do?
Yes.
I first read, and then it should give me an impression that yes, there is an arguable case. There is something that the tribunal needs to look into. There is something that a damage that's likely to cause, which cannot be otherwise compensated. All like love at first sight, like at the first look, whatever we get the impression, and that we get, and the lawyer submissions would further cement it, and the lawyer submissions will add to it. And that means, say, it's a probable, it is probable, we will say, we'll think that way. We don't go beyond it. That is what, according to me, is a prima facie. At the very first one.
Thank you, sir. Thank you.
So there is one question from Hari Krishnan, advocate, asking what is the difference between prima facie and balance of convenience?
No, both are different facets for grant of injunction. See, the prima facie case is, it's an overall case of yours, and from that we see whether we find something to adjudicate, something to see, and something to finally decide. That is prima facie. Now, balance of convenience is another facet. Balance of convenience, yes, you have a prima facie case, but the balance of convenience means ultimately we see, okay, merely because you have a prima facie case, we need give you because the balance of convenience is not in your favor. Then what is that balance of convenience? See, by granting that injunction, the loss that you are going, the other side is going to sustain, right? Or the interest of the public or interest of the defendant is going to suffer. Then merely because you have a prima facie case, if the balance of convenience is against, the balance is showing yes, there is going, defendant is going to suffer by this, public is going to suffer by this, or positively you are not going to suffer by not granting. Therefore, balance of conveniences. So unless both are there, injunction will not be there. Both are two different facets. You may have a balance of convenience, but prima facie case may not be, and vice versa. Unless both are there, it is. So both are two different facets.
Thank you, sir. Sir, you have referred to some citations. Probably as a conclusion, you can only give those citations.
Yes.
Read just that citation so that members can take note of that.
Yes. Firstly, I started with injunctions. Now, yes. Right. Now we will first start with the judgment of. Start with judgment of Justice Ramaswamy on injunctions. Justice K. Ramaswamy of Supreme Court. This is the judgment of 1992, but yet this covers the entire gamut of the.
Only the citation so that they can note it down.
1992, one Supreme Court case. 1992, one SC, page 719. Dalpat Kumar.
Okay.
Then we have 1993, three Supreme Court cases. Shivakumar Chadda versus Municipal Corporation Bill, page 161. Then
Yes.
we have this. Yes. 1999, 5 ALD, NCL Industries. A very good decision on 39-192. Then we have.
Page number, sir.
Sorry, the page number. Page number is. Page number is 318. 318. Then we have in the after judgment. That is, I have already given. That is, once again, I repeat. AR 1989 Madras, page 105. Injunction after judgment.
Yes.
Then injunction and trespasser. Then AR 1989 Supreme Court, page 2097. Then we have injunction by defendant. We have three judgments. One is 1987, 2 APLJ, page 97. Next, AAR 1989 Kerala, page 81. 1996, 2 Madras Law Weekly, page 205. Sorry, page 216.
Yes.
Page 216. Then we have, so far as the scope of inquiry is concerned, 2004, 2 Andhra legal decisions, page 31 by Honorable Supreme Court. Then we also have AIR 2011 Supreme Court, page 3101. Then inherent power. The earliest of that is AR 1926 Madras, page 258. And the latest of that we have is from what I have gathered, we could also have so many on that because these are the decisions repeated everywhere. So I take AR 1952, page 560. Then we have difference between. Okay, one thing I forgot to cover: difference between injunction order and stay, and that you can find. There is a difference between if the injunction against a person and then as a party, all that. Now, AR 1967 Supreme Court, 1386. This gives a clear picture as the difference between injunction order and order of stay. Then attachment before judgment. I have referred to one of the best judgments that we can have is an AR 92 Madras, 82 Madras, AR 1982 Madras, page 49.
Yes.
Very wonderfully written, followed by Andhra Pradesh also. Now we have one interesting judgment. 2008, two Supreme Court cases, page 302. It says that attachment petition is not to make an unsecured debt a secure. So it's very, very useful judgment from the applicant's point of view. Then we have, yes, 2000 in Madras I have given that. Now, AR 1982 Madras, page 49, I have given it. Now, appointment of advocate commissioners. Then, 2001, 6 Andhra legal decisions, page 101. 101.
1301.
1301.
Coming to the advocate commissioners, a question arose whether a second advocate commissioner can be appointed even while the first commissioner, advocate commissioner is there, without setting his report. Then the answer is it cannot be done unless it is set aside. Second advocate commissioner cannot be appointed. 2005, 5 ALT, page 646. And then receivers, as you all know, that Panchashi of Justice Rajamanna, and then other things are of course stay orders and all that. And we only discussed about the sections. We have
Thank you, sir.
in detail.
Thank you, sir. Thank you, sir.
They may be
It was
decisions, but I could not lay my hands to those. And
yes.
Please, any new questions are there, and they please take them into consideration.
Yes. Thank you very much, sir. Thank you on behalf of all the members who had participated. It was a very, very nice evening, an exhaustive session in respect of a very important topic. Nowadays, we are losing that sheen as regarding these interim orders and interim applications, which is the lifeline, as you said earlier. So in spite of all these tough times where you had difficulties moving around and you are confined to home, you are able to get us so much of information. And it really, as Satish was saying, thought-provoking. And every aspect which you have pointed out, it gives us new thoughts so that we can also keep reading on those lines and try to get judgments. Thank you once again on behalf of all the participants. Thank you very much, sir.
Thank you very much for your patience.
Thank you.